afternoon to all and welcome back. I would hope that you enjoyed the lunch and the break and that you are sitting now with refreshed energy to listen to the work of the conference panel number 2. This panel will look at, and I quote again from your program sheet, the impact of the tribunal on the future of global justice and the advancement and enforcement of human rights. The discussion will be moderated by no one else than Her Excellency Ms. Navi Pillay, the United Nations Commissioner for Human Rights. From South Africa, Ms. Pillay holds this crucial position as a High Commissioner since September 2008. She came to it from the International Criminal Court, where she had been serving as a judge since 2003. Before that, she had been serving as a judge at the International Tribunal for Rwanda, including a twofold term as the ICTY president between 1999 and 2003. High Commissioner Pillay will lead the discussion between the following panel's members. First, Mr. Richard Dicker, who has been directing the International Justice Program of Human Rights Watch since it was created in 2001, 10 years ago, and we know that Richard Dicker has done this with an exemplary energy. The other second panel's member is Ms. Orentlicher, Diane Orentlicher, who is one of the world's leading authorities on international law and war crimes tribunals. She now is the deputy of the Office of War Crimes Issues in the U.S. Department of State. She was appointed by Secretary of State Hillary Clinton from her position as a professor of international law at the Washington College of Law. His Excellency Stephen Rapp, the United States Ambassador at Large for War Crimes Issue, a position to which he was appointed by President Obama in 2009. This crowned a long-year career at the service of international justice at the ICTY and also at the Special Court for Sierra Leone, where he led the case against former Liberian President Charles Taylor. Professor William Schabas, who has inspired so many students in international law, human rights, and international human rights law in London, Galway, and Paris, respectively. In addition, Professor Schabas has been a member of the Sierra Leone Truth and Reconciliation Commission. And finally, Ms. Patricia Viseur, the former legal advisor for gender-related crimes at the ICTY, where she served as a prosecution attorney from 1994 until 1997. Currently a visiting fellow at the University of Oxford, where she teaches international criminal law, Ms. Viseur has brought her knowledge on gender-related crimes to Spanish courts, as well as to the UN Commission for Human Rights and the UN Special Representative to Children in Armed Conflict. I understand from Ms. Pillay that the panel is going to discuss the issue for the coming hour, and the second hour will be devoted to engaging in dialogue with you, as much as we did this morning, with microphones being distributed as long as you wish. Please, may I request your attention to listen to the panel under the leadership of Ms. Pillay.
Well, thank you very much for that kind introduction. And dear colleagues, I want to say that the panelists and I are very happy to be on a panel that will focus on the impact of the tribunal on global justice and human rights. As I observed, and you must have done the same, as we walked into the hall, we passed a large number of protesters who call themselves victims of Croatia. And so I hope this panel will very honestly address what ICTY means to people like them and the human rights of ordinary people all over the world. Now, the ICTY and ICTR delivered on the promise of Nuremberg to have a global rule of law where no one commits crimes that shock the conscience of humanity, and that means no immunity even for heads of state. ICTY established that with its indictment of Milosevic while he was still president. The beachhead of international law afforded by these normative, legal, and political adjustments emboldened forward movement to a point where international law no longer recognizes functional immunities in relation to international crimes. Even personal immunities can no longer be invoked in front of tribunals of an international character. In addition to the indictment of Milosevic, which I mentioned, those of Charles Taylor, Omar al-Bashir, and Muhammad Gaddafi confirm this. The tribunals helped pave the way for the ideal of an additional layer of justice operating on the global sphere, to be invoked in substitution or complementarity for the efforts or the failures of states in one of their core sovereign functions, the dispensation of criminal justice. The high-profile symbol of this new order is the International Criminal Court, but we also saw humbler efforts in Timor-Leste, Sierra Leone, and Cambodia. States are now more willing than ever before to entertain ideas of establishing justice mechanisms that will permit foreigners to participate in varying permutations in their internal justice systems aimed at addressing gross human rights violations. And as I sit before you as High Commissioner for Human Rights, I assure you that there's a great deal of interest within national states to have the international input, whether it's commissions of inquiry, investigation commissions, or even justice systems. Right now, we're helping in the DRC with their transitional justice system. But perhaps the most revolutionary feature of the Rome Statute, the principle that the Security Council, by way of referral, can impose the ICC's jurisdiction on states, also finds its precedence in resolutions 808 and 955 of the Security Council. Now, on providing definitional clarity, while delivering on the promise of Nuremberg, the ICTY also freed us from some of the Nuremberg Charter and judgment's jurisprudential baggage. Today it is clear that crimes against humanity can be committed in peacetime and war crimes in internal armed conflict, as was discussed by the first panel this morning. What I would like to emphasize is that definitional clarity provided by the tribunals has transformed human rights advocacy. Today, human rights advocates can revert with confidence to the concepts of crimes against humanity, war crimes, and genocide when drawing attention to situations of extraordinary concern. Indeed, the application of the responsibility to protect would be unthinkable without definitional clarity on when it is engaged. These and other matters will be addressed by Bill Schabas, who will be focusing on minority rights and the relationship with the European Court. On the ICTY and gender justice, where the Nuremberg and Tokyo tribunals treated rape and sexual exploitation as an inevitable and hence somewhat negligible side effect of war, the ICTY and ICTR recognized the centrality of these crimes and helped shed light on women's experience of war. In the Furingia judgment handed down shortly after the ICTR had held in Akayesu that rape can be a constituent element of genocide, the ICTY affirmed that rape can amount to torture. This rapist torture finding is not just a legal finesse, but has very real implications for victims. a little while ago, a human rights defender who had been raped by the henchmen of a military dictatorship told me how important it was for her to be able to present herself as a victim of state torture, given the stigma that rape unfortunately still carries stigma in her country of origin. I will leave it at this anecdote, as I'm certain that Patricia Sellers will provide us with a much more comprehensive review of the ICTY and ICTR advances and also our failings in the field of gender justice. Now, execution of arrest warrants, perhaps one of the most remarkable achievements of the ICTY is the fact that every single arrest warrant the tribunal ever issued was eventually executed. Not even Mladic and Karadzic have escaped the long arm of international justice. And Ambassador Stephen Rapp and perhaps Richard Dicker from Human Rights Watch will shed more light on the complex issues linked to this aspect of the ICTY's legacy. Let me just mention that one key factor was undeniably the fact that the member states of the European Union placed justice over narrow trade and investment interests in dealing with accession candidates from the former Yugoslavia. Conversely, I find myself time and again in a position of publicly upbraiding states, some small, some very large, that have refused to back efforts aimed at arresting or diplomatically isolating subjects of ICC arrest warrants. I can only hope that the rapid changes brought about by the Arab Spring will give leaders an occasion to pause, look at their trade relations and political alliances, and revisit their priorities vis-à-vis regimes that manifestly fail to uphold human rights. Global justice with local impacts. We are not here to present laudatory speeches for a venerable institution approaching retirement. Discussing a legacy also means acknowledging shortcomings, and the ICTY had a few notable ones. Global justice has to have a local impact. In this context, it has often been criticized that ICTY and ICTR failed to bridge the gap between them and the people who lived through the crimes under their jurisdiction. This was more than a geographical divide. So I do look forward to Diane Orentlicher presenting to us her research on public perceptions of the ICTY's work in former Yugoslavia. From my own experience, I can say that we waited too long to systematically reach out and explain our work, while local perceptions on the ground were gradually crystallizing into firm convictions. Now, on victim participation and reparation, the two tribunals, I must confess, did not provide much room for victim participation in the proceedings. Victims could not join proceedings as civil parties, let alone claim reparation directly in the ICTY or ICTR. And in this regard, I must acknowledge the consciousness of all the judges on the tribunals to this gap in their statutes, that justice was not fully rendered until assistance to victims, both in participation in the proceedings and reparation, are addressed. And I must join the voices this morning and also credit Judge, I was thinking whether it's retiring or outgoing. He's still the president of ICTY, President Robinson, who confronted the powers that be at the UN a few weeks ago, speaking for victims of all the victims who suffered as a consequence of the crimes tried by his court, and demanding that those victims be assisted. And I really wish you well and support your endeavors to raise funds for this trust fund. The tribunal's experience shows that retributive justice without reparation is not enough, But this does not answer the question how to provide reparation, where hundreds of thousands of victims and their families could present claims and many perpetrators are indigent. Clearly, the experience of the interplay between the findings of the ICTY and the subsequent judgment of the International Court of Justice in the Bosnian genocide case does not provide much of a response. A small word on early release and rehabilitation, which was also discussed in the morning's panel. The ICTY has triggered a lot of negative reaction among victimized communities who felt that it released victims like Biljana Plazgic too early, especially since the ICTR has refused to agree to the early release of any of its convicts. So although I was one of those who signed 5 sentences of imprisonment for the remainder of your life, as High Commissioner, I have a huge conscience about that sentence. I truly think that the question of parole and early release should be addressed. This is another gap in the statute. In fact, human rights law recognizes rehabilitation as an essential aim of imprisonment, which logically implies that even those sentenced to life imprisonment should have a chance to be considered for early release. However, I feel that we should think a bit harder about ways in which sentencing and early release practices can contribute to reconciliation in the society concerned. The paradigm of articulated administration of justice, the tribunals were exclusively international tribunals, and their jurisdiction enjoyed primacy over that of concurrent national jurisdiction. Developments since have entailed a steady movement away from this model to a paradigm where the international element is articulated just enough to ensure an effective and fair administration of justice. This paradigm is driven by concerns that international tribunals are too remote from local communities. Financial constraints are undoubtedly also at play, given that the ICTY and ICTR are expensive endeavors. In light of the many competing demands for international justice, it will not be realistic to lightly brush such pecuniary considerations aside. The first expression of the articulated model of administration of justice can be found in the complementarity principle set out in the Rome Statute. The ICC only comes in where national mechanisms are unwilling or unable to investigate or prosecute. The model arouses mixed feelings. On the one hand, it can create very divisive debates when some states clamor for the right and opportunity to try suspects themselves without necessarily being ready to do so. On the other hand, complementarity has had many positive effects. It has spurred states to integrate international crimes into their domestic law and launch prosecutions on this basis. Many even expand the basis for the exercise of jurisdiction in relation to crimes committed abroad, which has meant de facto travel sanctions for many perpetrators. I think what is often little understood is the fact that the fewer the number of cases that make it to the International Criminal Court, the better the Rome Statute regime works. A second aspect of the articulated administration of justice paradigm has been the setting up of hybrid tribunals in the affected country, either international tribunals integrating national judges or national courts that also have international judges on the bench. Hybrid courts may appear to be financially and politically more palatable alternatives to classic kind of international tribunals in the model of the ICTY. However, we have also seen the drawbacks for the independence and impartiality of the process where national judges and prosecutors remain under the sway of national executives or strong local opinions. Perhaps we have to consider whether the pendulum needs to swing back a little towards more international justice. So So with these remarks, I have great pleasure to hand over to the panelists, who will each take about 10 minutes, and I think I was below my 10 minutes. So, good example then. So Diane Orentlicher will be speaking on the experience of justice on the ground in the region. Thank you.
Can everybody hear me? Okay. It's such an honor as well as a pleasure to participate in this conference, which provides a very welcome opportunity to explore the historic and indeed transformational legacy of the ICTY. As we reflect at this conference on what the ICTY has achieved in the past 18 years, I find it instructive to recall early reports of its somewhat inauspicious opening. A press report, wire service account of its first day in business, published on November 18th, 1993, proverbially says it all. Quote, the first war crimes tribunal since World War II opened today amid doubt that it had enough documented proof or power to punish those guilty in the former Yugoslavia. So against these rather low expectations and daunting challenges confronting the fledgling tribunal, its subsequent achievements have been nothing less than remarkable. Before I say more, I have to say that although I am for 2 more weeks a U.S. government official, I'm going to be speaking today in a personal capacity, and my views don't necessarily reflect those of the U.S. Department of State. When I say I'm speaking in a personal capacity, I actually mean that in more ways than one. The opportunity to reflect with this really distinguished group on what the tribunal has achieved really couldn't be more meaningful for me personally. Like Georges Abissab, I'm feeling a bit nostalgic about the early years of the tribunal. I've had the very good fortune to be involved with this tribunal as an outsider from even before it was created. I was among a group that our ambassador, the United States ambassador to the UN at the time, Madeleine Albright, invited to advise her on what was then the draft statute of the ICTY. So I go back a long time with this tribunal. More important, when Richard Goldstone was appointed the first prosecutor in 1994, the first effective prosecutor, he asked me if he could, as he put it then, quote, call on me from time to time for legal analysis. And of course, I said, of course, having no idea then quite what I was signing on for, because that began a deep involvement in the work of the ICTY, working with the prosecutor's office in its early years. And I have to say, when I reflect back on that period, much of my work in those early years was very much in the nature, and I had the sense at the time, of legal archaeology. My students and I often felt we were excavating the law of Nuremberg and other post-war prosecutions, much of which hadn't been directly applied for roughly half a century. And we were then trying to rapidly fast forward and apply that law to contemporary issues. In rather stunning contrast, as people have remarked throughout the day, the jurisprudence of the ICTY and the other tribunals that followed in its wake are now very much a living, growing contemporary law, hardly in need of dusting off. It's being applied and interpreted in national courts across the world in a very positive development. Although I worked primarily with the Office of the Prosecutor in those early years, I soon came to know the tribunal's first president, Nino Cassese, and with others who have spoken today. I have to acknowledge that his passing is a terrible loss, but of course he leaves an extraordinary legacy. One of the reasons the ICTY has had such a global impact, and I think Judge Morone alluded to this earlier, is that it's benefited from really exceptional talent, very important factor in its leadership, judges, and prosecutors, among whom Nino Cassese was a towering judgment. But I also want to acknowledge there have been so many other important contributions. Judge McDonald deserves extraordinary credit for her genius in recognizing the importance of developing an outreach program several years into the tribunal's work. Madam High Commissioner Pillay, as we all know, played a pivotal role in ensuring that the justice of these international tribunals was also provided justice for victims of rape. I didn't go back and refresh my memory, but my recollection is that there was a dramatic moment in the ICTY trial when witnesses were bringing up evidence of rape, which hadn't been included in the charges. And as judge, she said, wait a minute. Why isn't this in the indictment? And the indictments went back and were refreshed. That was I may have gotten some of the details off, but it was an electrifying moment and a turning point in the attention paid to gender violence. So I want to sort of fast forward to roughly about 2006, which was 10 years on from the time I was last on the ground in Bosnia in my work for the ICTY. At that point, I was struck by the fact that there was a rich academic literature about the jurisprudential developments of the ICTY, but at that point, and this has changed, very little reflection on what its impact was in the region that was most directly affected by its work. So I undertook a study that tried to begin to get my arms around the question, what has this tribunal's work meant for people in the region? So I undertook a sort of an initial cut at this question from my point of view, looking at the tribunal's impact in Bosnia and Serbia, trying to understand, again, what has the work of this tribunal meant for people in the region, and also what would they consider success on the part of the tribunal. So I want to start in Serbia, where, of course, public opinion had long been overwhelmingly hostile to the tribunal. One striking point that I think had not been obvious to me until I began this research was that the work of the tribunal was deeply valued on principled grounds by a relatively small but very committed minority of citizens, which I think across time had been roughly 15% of the population who supported the ICTY on principled grounds rather than pragmatic grounds. And quite importantly, I think, the ICTY became a focus of their efforts, of their moral efforts to insist that their country come to terms with and acknowledge the role of its leaders in the violence in the Balkans conflicts. When I asked people in that category, the sort of committed 15%, why they supported the ICTY, what they thought it could accomplish, they mentioned several things, but they often emphasized in particular, and I think perhaps most often, they emphasized the role that they thought the ICTY's judgments would make in advancing Serbia's process of reckoning with the responsibility of Serbian officials for wartime atrocities. And when I asked, well, why the ICTY? There are other ways to do this, including domestic prosecutions. Their answer most commonly was, there is no other, and that's a quote from one individual, there is no other institution that at that time in the early years after the war could have played this role in Serbia, particularly during the Milosevic years. Now, it's challenging to try to capture how well these expectations of the role of the ICTY by those individuals have been met. But public opinion surveys that have been undertaken periodically since 2001 suggest that, at least for now, it's difficult to claim without significant caveats that the ICTY has had the kind of transformative impact its supporters in Serbia hoped for, and I think in many ways still hope will come to pass when it comes to altering widespread perceptions of wartime responsibility. At the risk of oversimplifying the results of these surveys, perceptions of the tribunal and the crimes it's prosecuted still correlate very strongly with the ethnic group to which one belongs, though there have been some subtle shifts over time. On the specific issue of whether the tribunal could help Serb citizens of Serbian nationality come to terms with the atrocities committed by Serbs, as of 2009, only 8% of Serbian Serbs who participated in a poll believed that ethnic Serbs committed the most war crimes. This contrasts with roughly 2/3 of the suspects indicted by the ICTY being ethnic Serbs. In a similar vein, 83% of Serb citizens of Serbian ethnicity believed that the group that had experienced the largest number of casualties during the 1990s conflicts were Serbians. At that time, the most reliable data indicated that a little over 10% of the wartime victims were Serbs, while almost 83% were Bosniaks. So that's one example of continuing gaps between what one might expect perceptions to be if they were following the ICTY's judgments. There are a number of factors that can contribute to persistent perceptions that these surveys reflect. And we obviously don't know now the ICTY's longer-term impact, which I think is likely to look quite different than now. But for now, I will simply note that despite these survey results, which do give us a lot to think about, many Serbians who've closely followed this issue believe strongly that the tribunal's work has, to paraphrase one Serbian lawyer, shrunk the public space in which leaders credibly deny key facts about notorious atrocities. As another Serb lawyer observed, there's incomparably less distortion of the past as a result of the ICTY's judgment. The ICTY's, sorry, apologies for the, I'm editing myself in light of time as I go along. The ICTY's supporters in Serbia also noted another achievement that they thought was fundamental, an achievement that can, I think, be impossible to capture in the public opinion surveys I mentioned. And that is quite simply the ICTY prevented impunity for the terrible atrocities that Serbian authorities had sponsored. Again, in the words of a Serbian whom I interviewed, this time a journalist, quote, "It's simple. If not for the Hague Tribunal, no one would ever actually bring to trial anyone who committed these crimes," end of quote. Another person said the message that this would have sent, quote, would be disastrous. The ICTY prevented that from happening. A final dimension of the ICTY's impact in Serbia that I'd like to briefly note, but I believe Richard Dicker will expand on this, is the tribunal's somewhat ironic and perhaps unintended role initially in spurring the establishment of a dedicated war crimes chamber in Belgrade. In contrast to the tribunal's direct and deliberate role in helping to establish a war crimes chamber in Bosnia, the ICTY didn't play the same kind of formal role in the establishment of Serbia's chamber, which began operating 8 years ago. Yet the ICTY had clearly a very strong impact. It provided a positive example of prosecuting atrocities in a specialized war crimes tribunal, and then a somewhat negative but effective incentive for the development of domestic war crimes processes. Nationalists who opposed the ICTY in Serbia thought it would be better to try war crimes in local courts than in the much reviled and distrusted Hague. Put differently, ironically, anti-Hague sentiment appears to have helped foster a more receptive attitude toward domestic war crimes prosecutions in Serbia than would otherwise have been the case. To be sure, and I want to acknowledge the democratic opening in Serbia following the end of the Milosevic regime was a critical factor in the establishment of the war crimes chamber. Several individuals who served in the Djindjic government said that they believed they had to address the country's role in the conflicts of the 1990s. As one of them told me, the Djindjic government saw the ICTY as very useful in helping to create a political space for Serbia to deal with, as he put it, the burden of war crimes in all its dimensions. So again, there was a confluence of factors, but the ICTY's role was very important in creating a greater political space. None of this is to say that the process of domestic prosecutions has gone flawlessly in Serbia or in most countries that have undertaken this. But again, I want to quote the views of an official, a senior official in the War Crimes Chamber. He said, "It was exactly through the Hague Tribunal that the process of facing the past was initiated in the states of the former Yugoslavia." And so the tribunal, I think, has, although the landscape is complicated, it's clearly played a critical role in helping to advance the process of reckoning, valued by the 15% of supporters of the tribunal in Serbia that I mentioned earlier. One final point on that, in the 2009 public opinion survey in this series that I mentioned, a majority of all those surveyed, including the majority ethnic group, said they thought that domestic courts reached a just result in cases finding Serbs guilty, and hence accepted what the domestic court had determined in those cases. And so in an indirect way, I think the suggestion from this latest poll data is that the ICTY indirectly helped lead to a process that led to greater acceptance of responsibility in a critical way. Turning, how am I doing on time?
Well over time.
Well over time. Should I talk about Bosnia later? in the question. Let me say one thing about Bosnia then, which was, I'm sorry, time flies when you're trying to cover a lot of ground. What I want to say about Bosnia, and I'm going to just try to reduce this to 2 sentences. Victims in Bosnia, as I think Judge Pillay alluded, have a fairly long list of grievances when you ask them what their experience of justice with the ICTY has been. Sentences are too short. Perpetrators are given early release and are out on the streets again, sometimes in their neighborhood, after getting short sentences, and so on and so on. And that's very real, and I think we need to come to terms with the lessons of those experiences. But what virtually everyone, if not everyone, that I interviewed in Bosnia said, either spontaneously or when I pressed them on how they felt about the ICTY in retrospect, given these concerns, to a person, they said that the most important thing the ICTY did was it provided justice, and this was something they desperately needed. And people, when I asked them about this, if they didn't bring it up, and I asked in as neutral a way as I could how they felt about the tribunal, they were passionate and sometimes offended that I even asked the question whether in light of their concerns they thought in retrospect it was the right thing to do. And so I want to emphasize this and end on this note, because in the academic literature there has often been just an extraordinary recognition of a wide array of goals that the ICTY should achieve, numerous academic theories about the purposes of justice, and what has often been obscured in the literature is what is most important to the people I interviewed in Bosnia, which is that without the tribunal, they would not have received justice. Thank you.
Thank you, Diane. I just didn't want to interrupt you because what you were saying brings such deep insights from the ground to our discussion. Really, thank you. So, Stephen, on just some of your success stories, maybe.
Well, the success story of my colleagues at the ICTY. First of all, I want to thank you for the opportunity to be here, and particularly to be here and follow my deputy. As you may know, the Office of War Crimes Issues, the ambassador and the deputy do a lot of traveling. I think last year it was 220 days on the road for me, and almost as many for Diane. And so it's only when we have conferences where we're both invited that we actually have a chance to get together and discuss the business of the office. So I thank you, President Robinson, for including us both on the invitation list and on this panel. Navi mentioned one of the great successes of the ICTY, which was bringing every one of the individuals that it sought arrest warrants on to justice. It was finalized in the last 6 months. On the 26th of May, 2011, Ratko Mladic was arrested, and in a few days was transferred to the detention facility about 2 kilometers from here on Pump Station Breg. And on the 20th of July, the 161st individual charged by this tribunal, Goran Hadžić, was also arrested and transferred here to face justice. That is a remarkable record. If you looked at my biography, I was a prosecutor in my home country, a federal prosecutor in Iowa, not a state known for its high crime rates, though I was very vigorous in maintaining public safety there. But I don't remember ever putting together a list of 161 cases and actually having all 161 people brought to justice. There were always those that managed to flee and to escape. And for this institution to do this is remarkable, but to do it at the international level without itself the powers of arrest, requiring state cooperation to fulfill that is a remarkable record, and I think sends an enormous signal around the world as we look at similar crimes committed in other places, that individuals who commit these crimes won't escape. It may not happen the next week, or the next year, or even within a decade. But the day will come when they will face arrest if the lessons that have been taught here are learned elsewhere. People cite, of course, the ICC, where there are now 14, I think, living individuals that have been subjected to arrest warrants. Only 5 of them are in custody and 9 are on the lam. But I think if the lessons are learned there, the day will arrive, just as it did for Slobodan Milosevic, that the door of the detention facility in Pump Station Weg will close behind Omar al-Bashir, or Joseph Kony, or Saif al-Islam Gaddafi. That day can arrive if the lessons are learned. This whole project of international criminal justice, of which I think practically everyone in this room is a vital part, is one of the most remarkable developments of our era. There's a book just published in the United States, a very academic book, but sort of the nonfiction book of the month, featured on the front pages of book reviews in the Washington Post, called The Justice Cascade. It's by an academic political scientist who looked at what's happened across the world in the last few years. The subtitle is How Human Rights Prosecutions Are Changing Our World. And it describes the waves in which this has happened, beginning with Nuremberg, then spends a fair amount of time talking about what happened with Latin America, with the prosecutions of the Guerra Sucia, in which our friend Luis Moreno Ocampo was involved in the 1980s. But also then the creation of these tribunals and what that has meant, and the expectations that have risen in the world as these waves have broken over the rocks. And indeed, we have a cascade. And my office is involved in some 26 different countries. I mean, some in which the crimes were committed 40 years ago, like Bangladesh. Others, like Syria, where they're being committed today. And people are saying, why not justice for us, like happened at the ICTY? And so the question is, how was it so successful here? First of all, I'd like to salute my colleagues in the prosecutors' offices, and the prosecutors that have served here at the ICTY, Richard Goldstone and Louise Arbour and Carla Del Ponte and Serge Brammertz. I never had the honor to serve here, though I will say that for 3 of my 6 years at the ICTR, I was under Carla Del Ponte, who was prosecutor of both courts at that time, and as I think everyone knows, she was a challenging person to work for, but extremely courageous and dogged when it came to this issue of bringing these fugitives to justice. And when these calls were made, they weren't popular and they weren't well received. If you've read her book, Madam Prosecutor, she describes and includes a copy of a letter written to her by Kofi Annan in March of 2001, in which he says, this business of trying to argue that countries in the former Yugoslavia shouldn't receive foreign aid or some kind of trade benefit because of non-cooperation with the ICTY, that's none of your business. That's politics. You shouldn't be involved in that. And she describes an encounter a couple months later when he actually says, well, how can everybody else be wrong and you be right? Well, she was right, and they were wrong. And Kofi Annan later admitted that in a congratulatory letter that he wrote her. Perhaps a small personal anecdote. I joined the ICTR about a month before the arrest of Milosevic, and I was thrown into the media trial under the presidency of Judge Pillay, and got to work very quickly trying to move to change witness list, to move to expand our witness list, to put on 21 new witnesses and exclude some others, and it was a very contentious thing. But Carla was very committed that we would also be indicting some people that were in Europe that had allegedly committed genocide in Rwanda. And since I was in charge of the media team, that included Simon Bakindi, who was living in refugee housing in Leiden, not 15 kilometers from here. And she wanted to have all these arrests done on the 12th of July. And we didn't have even a deputy prosecutor on Arusha at that time. So she said, you need to come to The Hague and show me the indictment, and I need to sign this. And I said, well, we're just getting going in the media trial. We're fighting this motion. She said, you need to come to The Hague. And I said, well, I can come the 1st of July. She says, that's too late. I have to go to Belgrade, to the donors conference, and insist on the arrest of Milosevic on the 29th of June. And I'm going to head over there at noon on the 27th, so you have to be in my office by 10 a.m. on the morning of June 27th. Well, on the evening of June 26th, Judge Pillay was reading out the decision granting our 17 additional witnesses, which we were very happy, and I could hardly bow and get out the courtroom and to make it to the airplane, to fly to The Hague, to shave at the airport, to rush up here and to bring the McKinney indictment before Madame Del Ponte. And I said, well, I'm glad I made it before you headed to Belgrade. She says, I'm not going to Belgrade. You're not? I do not go to Milosevic. He comes to me. And the following day, the 28th of June, the helicopter could be heard overhead, bringing Milosevic from the Eindhoven air base to the jail on Pump Station Weg. Indeed, what had happened is that the countries that would have come to the donors conference and donated funds were persuaded by Carla and by the strategy followed here not to contribute, not to participate if there wasn't cooperation by Serbia. But it, of course, went beyond that issue of aid and became critically tied into the issue of European Union accession. And the prosecutors, both Del Ponte and Brammertz, have continued to work with the countries of the European Union and established, as the ambassador from Luxembourg told us earlier today, about the standard that there needed to be a plein et intérieure coopération, plein intérieure, full and complete cooperation, before a country could be admitted to even the accession process, the stabilization phase of the European Union. And it was through that conditionality enforced by those member states of the European Union that it was possible to get, indeed, dozens of individuals here to The Hague, including Ratko Mladic and Goran Hadžić. It took that kind of effort. There is, of course, a lot of people that note that this tribunal, unlike others, has Chapter 7 powers, that the Security Council has given it sort of binding, the ability to make its orders binding on states. But it's not through those legal mechanisms at the end of the day. They may provide the basis for cooperation, though sometimes that also requires national law. It's through diplomacy and political pressures, through making the demand for justice and cooperation, that it's possible to actually bring people to justice.
Can you try and conclude now? Okay,
well, just a couple more things to say, because it also needs to be said that it's not, as Carla said in responding to Kofi Annan's letter of congratulations, she said, it's not me, the prosecutor, that deserves the congratulations. It's Prime Minister Lindich. It's who made the decision to make that transfer. And so much of what's happened also in terms of cooperation from the tribunal, indeed all around the world we have sanctions and threats of sanctions and various techniques that are used to raise the cost of non-cooperation with particular international priorities. But it was the way in which this tribunal also did its work and presented that work to the region, the importance of the outreach, the importance of people knowing that justice was being done here. Recall and the efforts that made sure that what was happening in court reached the region, remembering well the broadcast that followed the presentations of the Scorpions video here on June 1st, 2005, the last copy of that video obtained by Natasha Kandic and delivered up to the office of the prosecutor and shown in court and then shown in the region, really developed the attitude that what was happening, what these individuals had done, needed to be brought to justice before this tribunal. And finally, and judicially, and we talked this morning about Nino Cassesi and others have, but the very concept of individual criminal responsibility is, of course, the core, at the end of the day, to state cooperation and to the cooperation of a people. What happened in the former Yugoslavia was not the acts of great communities of great communities. It was the acts of individuals, people that made the decision to attack, to murder, to rape their neighbors. individuals that didn't stand for the values of those countries or any countries. And the way in which this tribunal has clearly established the rule, and in individual cases, case after case, held that it's individuals against whom justice is brought. It's individuals that are responsible for these crimes, not their neighbors, not their fellow citizens. That has, I think, made it possible for people within these countries to cooperate. And finally, and importantly, this has been an institution that has shown that justice can work, in which through tough presidential leadership by a series of presidents, this institution showed that you could try these complex cases, even if it meant sitting morning shifts and afternoon shifts, that you could bring these cases forward, that you could even order the prosecutor over her objections to cut the indictments and to reduce their size if that was appropriate, to show that justice could be delivered. So it's through the prosecution, through the judges, through the process that happened here, that in the end I think it was possible to have the influence, use the tools to bring people to justice. Mr. Crawford spoke this morning saying that, respect, I heard his comment that respect needs to be earned. Respect doesn't come down just from a blue flag or from red robes. It comes from the way in which the people that work in an institution do their jobs. And here at the ICTY, that work, I think, has earned the respect of the victims, but it's earned the respect of the entire world, and it's taught lessons that other tribunals should take to heart. Thank you very much.
Thank you very much, Stephen. I do recall that it was also very hard to stop you in the courtroom. But who can blame you with so much effort going into delivering on the caseload? So thank you very much. Patricia Sellers will talk to us about gender jurisprudence.
Well, I think I'll remain here and speak because there must be something about holding on to the sides of the speaker that just make the 10 minutes go by much quicker. So I hope I'm in a slower time zone. I'd like to speak about the gender jurisprudence, but if you would forgive me, I am not going to recount things that you might know. Rape is a war crime. Sexual violence is part of genocide. Sexual violence is part of torture. That sexual violence happens to men and boys, as well as to girls and women. What I would like to talk about is something a bit more subtle, something that has not really reached neither the academic literature nor the judgments, the content of analyzing the crimes. And that is what I would call the heart of the international law, be it international criminal law, humanitarian law, and human rights law. When prosecutions went forward at the ICTY, and there was a huge outcry in terms of what will you do in terms of justice for women, much of that outcry was centered on make rape a war crime, although it had been already a war crime, recognize it then. And a lot of the outcry was kind of demeaningly referred to as being PC, politically correct. I would like to say it was JC. It was jus cogens. The sexual violence and the addressing of crimes that were committed against females, girls, and women was part of the endeavor to address what were just jus cogens crimes, war crimes, crimes against humanity, genocide, that are to have the highest ranking in any of our legal orders. If one wants to look at international human rights law, we might look at those human rights from which there can be no derogation in times of war or in times of peace. Well, not only do they include slavery, to which the gender jurisprudence filled out the contours of, they include torture, to which the gender jurisprudence also filled out the contours of. They include war crimes, crimes against humanity, and genocide as types of human rights violations. Now, by that, what do I mean? Since the jurisprudence of the ICTY, we have looked at the regional human rights courts, in particular the courts from Latin America, to a much lesser extent the European human rights courts, but also to the regional instruments coming out of Africa, of recognizing that the violation of that bundle of human rights can be termed crimes against humanity. Another word for that bundle of violations is genocide. And these are crimes that are to be pursued irrespective of where they occur, and they are to be pursued by states irrespective of whom either the victims or the perpetrators are. So what does the gender jurisprudence do to that? It allows us to understand that within the war crimes notion of protected persons, there are no extracting of the females out of any protected group under Geneva. The Geneva Conventions might offer women and children more protection, no adverse discrimination, but they certainly never divide the protection that's to be given to the group. The same way with crimes against humanity. The attack against the civilian populations, by its very terminology, civilian population, includes both men and women, boys and girls. It is gendered from its very root. And I would repeat the same analogy with genocide. Even though you cannot commit genocide against a gendered group, or women per se are not a genocide group, there is not one of the genocide groups, national, racial, religious, or ethnic, of which women or females can be extracted. Now, maybe this is so obvious, so subtle, it is as if we don't perceive what we are looking straight at. What the gender jurisprudence of the Yugoslav Tribunal has done has to kind of fettered out the contours of jus cogens, of our understanding of those crimes. And I would add, and it might be a bit controversial, but I want to recall that one of the first controversial articles I read back in the late 1980s, 90s, Professor Orentlicher, about the duty to prosecute. Once a jus cogens violation is discovered, acknowledged, you have obligations, erga omnes. These are binding obligations on the state, and one might add, on the jurisdiction that can prosecute, possibly an ad hoc tribunal or the ICC. And what are those obligations? Usually do mention prosecute or extradite. But in order to prosecute, one has to investigate, prosecute, and adjudicate. There, the ICTY gender jurisprudence, too, assist us in understanding what is the true investigation of what might have happened to the gendered groups when you look at genocide and crimes against humanity. The ICTY has spurred almost a way to look back and understand the Holocaust by seeing what happened to men, women, girls, and boys, and what happened to each of them in terms of sexual violence. Right now, I know that states such as Guatemala are looking back at the Guatemalan genocide. To look at what only happened to the men is not to really look at the full genocide or perform your jus cogens obligations of true investigation, prosecution, and then for the judge's true adjudication. I would say that what the gender jurisprudence has done and is continuing to do is but a prequel. It is the runner that before he goes forward takes that step back. And it is an understanding backward. Now, what is a Holocaust as gendered? What do the Geneva Conventions cover? Crimes against humanity, how does one attack a civilian population, its composition and acts that can attack the different persons in that composition? And the same with genocide. Gives that legal strength of that runner to dash forward. The gender crimes were not supposed to have worked so well at the ICTY. They were supposed to have been present on duty when called, but never to have developed to the extent that they actually filled out international law itself and allowed international criminal law and now international human rights law to be much broader. For example, whether one looks at the review of Article 31 by the International Covenant for Civil and Political Rights, General Commentary 31, when you say what is a right to a remedy, even what should be remedied is fuller because of the gender jurisprudence. And who has a right to a remedy depends on us understanding what is the violation so that we can understand who has the right to the remedy. This is just among the impacts of the gender jurisprudence of the ICTY. It was an imperfect success. There should have been many more investigations, prosecutions, possibly different ways of seeing the adjudication. But I want to emphasize success as much as I want to emphasize imperfect. It was the beginning of a long journey of where the runner got her footing and could allow all of us to dash forward. Thank you very much.
Thank you so much, Patricia. So now we have Richard Dicker, and you will speak on the legacy with regard to state cooperation and the impact on national proceedings. Thank you, Richard.
As others have said, I feel very privileged to be here on this occasion of really trying to assess the legacy of the tribunal, and all the more so mindful of the untimely passing of Ninoka Sesi, who was a great friend to the human rights movement and to my organization in particular. In my remarks, I will speak to two issues, some of which have been touched on, where the tribunal's legacy for global justice is particularly instructive. These are, first, ensuring recalcitrant state cooperation with judicial orders, particularly arrest and surrender, and second, spurring prosecutions of these same kinds of crimes by national authorities. First, cooperation. The success of international tribunals is directly linked to the will of states and intergovernmental organizations to support the judicial mission. That is a truism that bears frequent repetition. Cooperation in the form, in particular, of arrest and surrender is obviously the precondition for judicial proceedings, trials, and ultimately justice for victims. There is a long history of trying to compel cooperation between the tribunal and governments in the Western Balkans, and that goes back before the Dayton peace talks. A word of history here first. In 1997, a Foreign Affairs Council meeting at the European Union specified that among the Copenhagen criteria for EU accession that had been adopted in 1993, full cooperation with the ICTY was a requirement. Then 2 years later, building on these conclusions, the European Commission included ICTY conditionality in the stabilization and association process it adopted for the Balkan states. Meanwhile, the United States government had used its economic support funds as a linchpin for its conditionality approach to the Western Balkans. I recall March 2002, I believe $40 million of U.S. economic assistance was withheld from Serbia because of lack of cooperation with the tribunal. This linkage with EU accession and U.S. economic support not only was an unprecedented development, it was also a proactive, smart use of diplomatic economic clout on behalf of justice and accountability. And I believe it changed the game and created a new standard in linking justice and other objectives important to recalcitrant states. As a result, and has been alluded to, with the tenacious efforts of tribunal staff, the ICTY has a stunningly successful record of arrest and surrender, which is, I contend, one of its most important but hardly sole legacies.